Thank you. Hope all well with everyone.
Daily list for motion, item 1.
This is a contempt petition, and what I have seen is that nothing has been done.
Yes, my
Plus-
lord, nothing has been done.
Uh-huh.
Nothing has been done by
Yes,
the
and
respondent
in fact-
authorities, my lord.
And of course, the order is to consider.
Yes, my lord.
But the fact remains that there was another direction that she has to be given written reasons and right. There was another direction that if that is not done or whatever, she has to be supplied with the reasons.
Pardon, my
See
lord?
this, take a decision. Where is the other party? You are for the petitioner.
Yes, my lord.
And where is the other party? Where is the government respondents? Oh, today it has come up for the first time.
Yes, my lord, this has come up for the first time, my lord. So, my lord, this is a contempt petition filed by the petitioners against the respondent contemptors in non-compliance of the judgment and order dated 1st May 2025 in WP CRL number 2 of 2024, my lord. So, my lord, direction was made by this honorable court to reconsider and revisit the case of the petitioner, my lord, so that in his claim for compassionate allowance and encashment of his unutilized earned leave, my lord. If I may take your lordship to annexure one of my petition, my lord. The
I've
order.
seen. The directions are at page 19, right?
Yes, my lord.
And
At
so,
para 13.
Secretary to the Government of Mizoram shall take necessary exercise for considering the case for compassionate allowance as well as within 2 months, right?
Yes, my lord.
And from the date of receipt, the said authority shall also consider the claim of the petitioner for encashment
Yes, my
of
lord.
unutilized earned. Of course, these are all considerations.
Yes, my
But
lord.
the second direction, the respondent authority concerned shall take a decision as directed here within the time frame provided by passing a reasoned and speaking order. Nothing has been done, right?
Nothing has been done, my lord, and no communication has been made either.
So, okay, today notices will go. Let
Yes,
us see what they come with.
My lord.
Okay. Heard Miss, your Miss?
Daphne Shoiklongi, my lord. My
Okay, your name is not there.
It's
in
not
the-
there, madam.
Acha, acha. So and so for the petitioner. This is a petition. This is an application filed under section 12 of the Contempts of Court Act 1971, read with article 215 of the Constitution of India, for initiating a contempt against the respondent for disobedience of the judgment and order dated 1/5/2025 passed by this court in writ petition within bracket criminal number 2 of 2024. In the said order, it was directed that the Secretary to the Government of Mizoram, DP and AR, shall undertake the exercise for considering the case of the petitioner for grant of compassionate allowance within a period of 2 months from the date of receipt of a certified copy of this order. It was further directed that the authority concerned shall consider the claim of the petitioner for encashment of unutilized earned leave, encashment of unutilized earned leave as permissible under the CCS leave rules 1972. It was also directed by the said order that the authority should comply with the direction within the time frame by passing a reasoned and speaking order which shall be communicated to the petitioner, or which shall be known with further communication to the petitioner. Issue notice to respondent number sole respondent, issue notice to the respondent, the petitioner to take steps for issuance of notice by registered post with EDI or with usual process
Yes, my lord.
within a period of 2 days from
1 week, my lord, if
1
possible.
week, within a period of 1 week. List the matter after 2 weeks.
Deeply obliged.
Item 2.
Yes. This is a criminal petition.
My lord, yes, criminal petition filed under my lord section 528 of the BNSS.
I have gone through,
My lord.
this because I got time yesterday.
My lord,
I've gone through, this is what that Israeli national, right?
my lord,
And the lady, the mother,
My
is
lord.
inside the jail.
inside, yes, judicial custody, my lord.
Otherwise, the complaint is against the husband, mainly
yes,
the husband.
Yes, yes,
And the mother, of course, there are some allegations, but
My lord.
not exactly confining to the mother, right?
my lord,
They
my
said that relatives, she spoke with the relatives,
lord, my lord,
and they did not give her any positive reply and all, right?
my lord, like that.
So, what is against the mother? Just show me.
My
And
lord,
the first order, where mother was made as an accused, that you have not annexed perhaps.
my lord, that was annexed in the criminal petition.
No,
That-
I'm seeing the criminal petition only. Show
My
me.
lord, here, if your lordship may kindly see the order passed by the trial court on, and
29.5 order I have
9/6.
seen.
9/6/2025, page 34. The 33 and 32 is the scanned copy and 34 is the retyped copy. My lord, if I may read the
Yes,
retyped
9.6.
copy. At second paragraph, my lord. The accused Srimati Lanjuri has been added as co-accused.
This is not in this date, this was perhaps done earlier.
No, my
The
lord.
accused Sri so-and-so has been added as co-accused with respect to this complaint on grounds of cheating. What you mean to say, this is the first order where she was made an co-accused?
This is the first instance of writing about the addition of the present petitioner as the co-accused in the
But
criminal complaint.
see the order before that, 29.5? This is 9.6.
Yes, my lord. If we see that 29/5,
Huh.
since the present petitioner came from Israel to India, and as the main accused was in Israel, so the counsel for the complainant had submitted and seek the trial court to issue summons to the present petitioner, my lord, to appear before the court only. And during this relevant period, she was not added as the co-accused.
That order is not there. A prayer is made by so-and-so to summon. This order you have not annexed.
If I may read, my lord, the retyped copy.
Read it. Which one?
From that page 31, the retyped copy is at page 31. This order is 29/5/2025. Learned counsel for the complainant is present in court. Today is fixed for appearance of the OP's mother, Srimati so-and-so, mother of the OP, Sri David Siyama, as summoned. However, she is
OP's mother, why 2 times it is written? Today is fixed for appearance of opposite party's mother. She is the petitioner. Mother of OP, Sri David S. summoned. Okay.
mother of the OP, Sri David Siyama. David is the main accused, my lord.
Yeah, the husband.
And the mother is the co-accused. However, she is absent again, and learned counsel stated that she refuses to appear before the court. Learned counsel made a prayer to compel Srimati Al-Naziri to appear before this court by issuing warrant of arrest. Counsel stated that the Srimati so-and-so herself and two other persons went to the home of the complainant sometime in January of 2023 as Palai. Palai means mediator,
Acha.
to discuss marriage proposals before the complainant and the OP, Sri Devi Al-Nusima, were legally married as per Mizo marriage customs. However, the OP's mother now refused ever doing such a thing alleged and refuses to acknowledge any marriage between the parties at all, and as such, OP's mother, Srimati Al-Nunziri, is a crucial witness to the instant case. Meaning
Again they
that
say
crucial witness only.
witness.
Stated as crucial witness only, Malon. And learned counsel further stated that the OP's mother is also a citizen of Israel, and she is physically in Aizawl on a temporary basis, and her arrest is warranted on the ground that she may soon return to Israel and justice may not be served to the victim, that is the complainant.
That means she came in between
Yes.
to the country.
After filing this criminal complaint, as the main accused is in Israel, so the co-accused, the mother, came to Aizawl, and in the meantime, the learned counsel for the complainant seek to summon the mother due to the absence of the main accused only. During this relevant period, she was not added as a co-accused. So, my lord,
So
here,
on 29/5 she was not the accused.
not the accused,
She was a witness.
only, yes, just to know what is the,
And she was summoned as a witness.
yes, my lord. So, as she failed to appear, then the warrant of arrest was issued, and she was produced on 9/6, and on that day, from the day onwards, she is detained in judicial custody till date. So, my lord, here the main issue is that if your lordship may already see all the petitions, what we want to submit before this honorable court is that, being a citizen of Israel, initiating criminal proceeding against a foreign national is not appropriate as per the relevant provision of section 308 BNSS. Madam. Read with section 4 of that BNSS.
How to deal with the
In order to deal with that,
Non-nationals?
if under such a situation, there is an extradition treaty signed by the
extradition.
government of India and the government of the state of Israel in the year 2022, if I'm not mistaken.
it's still valid, the extradition treaty?
That's still valid, my lord. So, in order to initiate any criminal proceeding against a foreign national, then the central government, the Ministry of Home Affairs shall issue a sanction. An appropriate sanction shall be issued, and then extradition process shall be initiated.
Those not been followed at all, nothing?
Those proceedings
Mother
were
came
not
here.
followed at all, my lord, yes.
Mother came here and she
Mother
was...
came here and she was simply arrested and detained in judicial custody for more than last 1 month. So they are planning to visit their family relatives, and now her visa is almost expired. So still we also
She
applied
is
for.
otherwise from here.
She's otherwise from here, but now, for the last 10 years, they were the Israeli citizen. They came here with Indian visa. They are having the Israeli passport and all those e-visa very properly. So, my lord,
Okay, today let the notice go
my lord,
to the complainant.
my lord,
Okay, that
My
will be
lord.
enough.
my lord.
Um,
In the meantime, my lord, I am seeking
you are praying for some interim.
interim, yes.
Interim in what way?
The operation
Stay
of
of
the stay of the criminal complaint, my lord, till any further order, till next returnable date or something like that, my lord.
Stay of this criminal proceeding. You have not filed for bail and all. She is...
I have filed for bail and the bail order was reserved for the last 2 weeks,
Oh, not given.
not given. Even allowed or
Before
rejected
before the trial.
before the trial court.
Trial court. The complaint was lodged in which year?
Complaint was-
2024.
My lord,
And then why did she come here? Mother came here? She
Mother
didn't know
came-
about this complaint?
no, she did not have any knowledge at all. She came with the husband and the daughters just to visit the relatives. And the daughters already returned back because their leave already was finished. And the husband is still waiting for the mother.
It is reflected, yes, here. Okay. Issue no, yes, wait. This is an heard Mr. So-and-so, right? And yes, for the petitioner. This is a petition under section 528 of the BNSS against the impugn order dated 9/6/2025, passed by the Judicial Magistrate First Class, Roman 5, Aizawl District, Aizawl Judicial District, Aizawl, Mizoram, passed in criminal complaint number 597 of 2025, registered under section 82 of the BNS, by which, no, not by which, 82 of BNS. It is the case of the petitioner that before the impugn order, an order dated 29/5/2025 was passed, by which the petitioner was arraigned as a witness to the present complaint. The petitioner was summoned, but however, since the petitioner was a national of the country of Israel, she couldn't be present before the court. Before this, you mark it. Before this, you write another paragraph. It is the case of the petitioner. This is what I stated. The case of the petitioner that a complaint was filed. I did not say about the complaint. A complaint was filed by complainant, namely Srimati Ethel, Ethel Lal Ruad Diki, Lal Ruat Diki, alleging inter alia. Oh, before what? Where is the complaint? It's there. Yeah,
My
it's
lord,
there.
yes.
Before the Court of Chief Judicial Magistrate, Aizawl District, stating inter alia that she was married to the complainant in the year 2023 by registering the same under section 13 of the Special Marriage Act. It was further stated that the respondent, who was a Israeli national, came to Mizoram for his vacation and that the marriage was solemnized during that period. She thereafter stated that after 1 week of marriage, respondent went back to Israel with a promise that he would come back soon to take her back. The complainant, however, stated that after reaching Israel, the respondent went back on his promise and did not come back to take her, but the respondent advised her to start a small business, to which he also promised to help her monetarily. In view of the said advice and promise, the petitioner took loan from Mizoram Rural Bank with an interest of 10% per annum and started her business. She then stated that in the month of July 2024, she received the news that the respondent was getting married to another lady in Israel. And on getting the news, she called up the respondent as well as his parents and other family members, but none of them gave her any details in the matter. The petitioner, the complainant further stated that thereafter the respondent contacted her and requested her, contacted her and by admitting his guilt, requested her to move on. And promised her that monetarily he'll keep helping her. But he did not help as stated by the complainant. It was also stated that the respondent thereafter married to his second wife without nullifying his marriage with the complainant, and when she again tried without nullifying the marriage with the complainant, it's okay, and when she again tried to speak about the problem with the family members, she was informed to let it go by the family members on the ground that she cannot do anything against the same, as they have changed their nationality or as they have changed their citizenship, and that all her efforts will be futile. The complainant as such filed the complaint. For punishment under section 82 BNS, and also claimed monetary relief from the respondent. Then you come to that order. It is the case, you cut it. Then you say that para, it be stated here that before the impugn order dated 29/5/2025 was passed, by which I have already said mother was arraigned as a witness, right? Mother was arraigned as a witness, and the summons were issued to her, and she was in so and so, she could not appear, right? Could not be before, as stated by the counsel for the petitioner. And the learned court, due to the absence, and on the ground that learned counsel for the complainant stated that the petitioner refused to appear before the court, non-bailable warrant of arrest was issued against the petitioner under section 358 BNSS and fixed a case on 3/6/2025 for appearance. 3/6 what happened? Nothing. On 3/6?
3/6, on 3/6, my lord, that I did not annex in the petition.
Thereafter, on 9/6/2025, the petitioner was added as a co-accused with respect to this, with respect to the instant complaint on grounds of cheating by the learned court, Chief Administrative Officer. No, what is this court? Chief Judicial Magistrate.
My lord, Judicial Magistrate, First Class 5. Initially, the case was
CJ.
filed before the CJM, but it was endorsed
Acha.
before
By
the.
Judicial Magistrate, First Class 5. It was further observed in the order that on appearance of the petitioner on the said date, what did I say? On her appearance, no? Date. On appearance of the petitioner, who was accompanied on the said, who was accompanied by her husband. The husband created nuisance in the court premise, and although an attempt was made to listen to her story, due to her husband's erratic outburst, the petitioner was sent to judicial custody, and the matter was fixed on 13/6/2025. It is this order that the petitioner has challenged in this criminal petition? Full stop. It is a bare perusal of the complaint petition shows that the allegations were mainly against the husband who had stated to have cheated her, who is stated to have cheated her by marrying another lady without nullifying the marriage with the complainant. Allegations were also made against the husband of not helping her monetarily after advising her to start a business. Only allegations against the relatives was that they did not give her the details of the marriage of respondent with another lady. Actually, the term used in CRPC or BNSS is women, no? Not lady. In some provisions, is it lady or woman? In some provisions, I remember, I think in bail.
Woman.
Woman. So wherever I have seen lady, make it woman. Another woman. And the further allegation against the relatives of the respondent was that they told her to let go the issue and that she won't get any help from the courts as they have changed their citizenship. These allegations were made against the relatives of the respondent and not against the mother specifically, right? It is writ large that the allegation is against the husband and as such this court allegation against the husband. No, this will have any, it's okay. Against the husband. As such, this court stays the proceeding of the criminal complaint number 597 of 2025 till the next returnable date. Issue notice to the respondent, returnable by 3 weeks. The petitioner to take steps for service of notice upon the respondent by registered post with AD as well as with usual process. List the matter after 2 weeks. Or maybe 3 weeks, no? 3 weeks.
For admission, item 3.
My Lord, notice is complete.
Yes?
My Lord, I'm appearing for the respondent number 4. If your lordship may give me another 3 weeks time to file my affidavit in opposition.
Or you're filing, security deposits were freezed, right?
Yes.
Yes, my lord.
One of the issue of maintainability is, I think, is there in this case. Because,
On maintainability on what ground?
because she has not challenged the order of the learned special judge, which frees the security deposit.
It is challenged, my lord.
She came directly by way of filing writ petition, my lord.
My lord, let them file the affidavit and after that we can
Yeah, yes,
decide the matter.
Heard Ms. So-and-so for the petitioner, as well as Vanheshami.
Yes, Your
I
Lordship.
remember Vanheshami, the government advocate, additional AG. No,
Government advocate.
government advocate for the state of Mizoram. And Mr. So-and-so, you are for all the 1, 2, 3?
I'm for the respondent.
1, 2, 3, 5 and 6.
Appearing for 1, 2, 3, 5 and 6. Mr. So-and-so appears for respondent number 4. You have filed your wakalat now?
Yes, my lord.
C. Lal Fak Zuala.
Yes,
Yes.
my lord.
So-and-so for respondent number 4. The a prayer is made on behalf of respondent number 4 by Mr. So-and-so to that he would like to file an affidavit in opposition to the...
Similar prayer, Your Lordship.
Oh, you will also file, right?
Yes.
Okay. Affidavit in opposition to the present writ petition, to the present petition. Ms. Venhesyami also prays that some time may be also allowed to her to file affidavit in opposition. Prayer is allowed. List the matter after 2 weeks. In the meantime, both the parties may file their respective affidavit in opposition.
Obliged.
By giving a copy to the petitioner. By giving copies to the petitioner.
Item 4.
Here I think counter is not filed by him, right? Mr. Malhotra?
Notice was issued in March, the end of July, Your Lordship. I mean,
Your Lordship.
5 months have passed.
Acha.
I'm appearing on behalf of the state respondents. We are yet to receive any instructions from the state, Your Lordship.
5 months, Your Lordship.
And
just received
I have
instruction.
I've sent a reminder as well just last week, Your Lordship. So if 3 weeks time may be granted, because the main contention here is regarding the financial liability of whether the society will give or the state respondents will give the pension.
That is not the case.
In fact, now the case is that it is amendment was quashed.
And we have to
Now
be paid
he
our
is
pension.
entitled.
It's our right to enjoy a pension. And pension is not a bounty. I mean, it's between the government and the KVI. I mean, let them file let the records be called for. I mean, 5 months just to file an affidavit.
You take the instruction as soon as possible on filing?
Yes, Your Lordship.
The respondents number 1 and 2 also have still to file the affidavit.
My Lord, I'm appearing on behalf of my senior. Lord, what please silence. We are presenting respondent number 1 and 2.
Yeah.
My Lord, we are not yet received Paraguay's comment from MKVI.
On the last occasion also, only you had said, learned counsel on so-and-so appears for 1 and 2, 3 weeks time to file counter. In the month of June, 2/6/25, you had taken 3 weeks to file counter. And then,
And they have not received Paraguay's comments for the last 5 months.
try to get it as soon as possible, right? Both, you are for 1 and 2 and you are for 3.
Yes, Your Lordship.
And then both of you file as
Yes,
soon as
Your Lordship.
possible. I'll give, okay. But 3 had not, in view of matter stands to respondents to, by the, it is reflected from the last order dated 2/6/2025 that time was given to all the respondents to file their respective affidavit and oppositions. However, today, when the matter is called up, prayer is made on behalf of all the respondents that they would require some more time to file their affidavit since instructions were awaited. In fact, you're right. In fact, the prayer for filing affidavit in oppositions were allowed wide. The first order dated, not the first order, wide order dated 13/3/2025. As such, it is directed that that the respondents may file their affidavit in opposition without any further delay. The matter to be listed on, I'll give you a date.
Yes,
Listed on, we'll give you 2 weeks, okay, and not 2 weeks, 1 week. The matter is listed on, to be listed on 11th of August. 11th of August is sufficient time, 2 weeks. 11th of August 2025, by that time, the respondents may file their affidavits. And by giving the copy to the petitioner, without fail.
Item 5.
Same, I think.
Similar order.
Or similar order. Similar order. Here also the
Yes.
petitioners are different.
Yes.
They were all retired.
Yes.
Yes. Same
Similar.
order we will follow.
For orders,
Names will be different.
item 6.
This is condonation, right?
Yes, my lord.
There is a delay of. This is an
344
condonation and
days.
leave
Special leave application, yes,
to file appeal
Yes, my
against
lord.
what? Acquittal order.
Acquittal, yes.
Acquittal.
Yes, my lord.
Acquitted under what?
Under section 130, 135 of the Custom Act, my lord.
Customs Act.
Yes, my lord.
Smuggling.
Yes, my lord.
Where is the acquittal order in the main? Oh, acha, it is yet to be. So and so, yes. Right. So, you are appearing for
I'm appealing for the respondent.
respondent.
Yes, Your Lordship.
You have objection to the
Yes, Your Lordship.
delay.
I need some time to file an objection.
Objection. How many days delay?
344 days, my lord.
So almost 1 year.
Yes, my lord.
You can fight on merit.
Yes, Your Lordship. Let me file my objection first. After that, we can discuss it.
Okay. Because after this is on delay, then again
Yes.
leave.
Leave
Unless
also
the
delays.
Delay is condoned, leave will not be taken up after that.
Yeah.
So, okay, heard, this is an application. Which one? This one, right? 27, right? IA?
IA 27, yes, ma'am.
This is an application filed under section 419, subsection 5 of the BNSS for condoning the delay of 344 days in preferring a special leave application as if SLP, leave application in filing the criminal appeal, right? What did I say? Delay of 344 days in filing the connected criminal appeal which is preferred challenging the impugned judgment and order dated 25/1/2024 passed by the Chief Judicial Magistrate Shamfai. Chief Judicial Magistrate appeal will lie to the session judge. What happened?
I beg your pardon, Lordship.
Huh?
Can I beg your pardon, Lordship? I don't get your question, my lord.
I cannot get you. What?
Yes, my lord.
Because what? Against Chief Judicial Magistrate order, you go before session judge, then you come to High Court.
Lordship, I am only appearing on behalf of my senior, so...
Now you take proper instructions because the impugned order is by CJM.
Yes, my lord.
Then you go before session judge. Let me see the impugned order. Chief Judicial Magistrate only. You have not filed it before the session judge. If session judge again against acquittal, right?
Yes, my lord.
So against acquittal, you have to go before session judge, right?
Yes, Your Lordship.
See, give me BNSS. But, see 419 of BNSS, appeal in case of acquittal.
Yes, madam.
Save as otherwise provided so and so, the district magistrate may in any case direct the public prosecutor to present an appeal to the court of session or an order of, this is state appeal, by any direct the remand so and so of acquittal other than a high court. To a court of session for from an order of acquittal to the High Court from the original or appellate order of acquittal passed by any court other than a High Court, not being an order of acquittal passed by it. No appeal shall lie before except with the leave. Is such an acquittal so and so? Okay, no application of after the exercise of any case appeal against. So you examine the matter and then you come.
Yes, madam.
Okay.
Yes,
You speak to your senior
Yes, my lord.
and see whether the appeal lies to the High Court or the Court of Session.
Okay, my lord.
Okay.
Will do.
So as prayed for by Mr. So and so, cut that.
Let me examine.
Or you write in a different way. This is an appeal filed against the judgment passed by the learned Chief Judicial Magistrate. Achha, this is Union of India's appeal, the central government's.
Yes, yes, my lord.
There is a provision here, no, for central government. What did I say? 319 or what? Achha, so subsection 2, see subsection 2, into an offence under any central act, it is what? NDPS or what? Customs or you said customs. Into an offence under a central act, other than this Sanhita, the central government may, subject to the provision, also direct public prosecutor to present an appeal to the Court of Session from an order of acquittal passed by a magistrate in respect of cognizable and non-cognizable offence. So first blush it seems that you have to go to the Court of Session. You speak to your CGSC or whoever. Okay? So no need to write. Mr. So-and-so appears and so-and-so. As prayed for by so-and-so, list this matter after a week
Yes, my lord.
or 2 or 3 days.
2 weeks, my lord.
Not 2 weeks. You take the instruction whether it will lie. Then I will issue notice on the condonation.
Yes, my
Okay?
lord.
You take it by Monday.
Yes, my lord.
As prayed for by so-and-so, list the matter on Monday. That is on 4th of August. In the meantime, Mr. So-and-so would take instruction as to whether this criminal appeal lies before the High Court or the Sessions Court as per the law. Okay, you take instructions.
Obliged. Item 7.
Lordship, with regards to this item, can the matter be come
Wait,
upon
wait.
tomorrow, my lord?
One second. Let me arrange my files. Yes, what is that?
This is the
Same.
first time.
Union of India.
Yes, my lord.
This is also from CJM.
Yes, my lord.
CJM. You take instructions. Same order, huh?
Yes, my lord.
Take instructions.
Deeply obliged.
Item 8.
May it please your worship,
Yes.
as per the directions of this Honorable Court, we had served notice upon the respondent number 5 through Dusty, and the concerned affidavit has also been filed.
Ajay.
So notice on respondent number 5 may be deemed to be complete. And your worship, the application is for substitution of the appellant.
Number 5 has appeared or no one?
No one, none.
No. Correspondent number 1.
This was on 25/7 only, very recently.
Yes, yes.
The office notice 25/7 saying that AD card upon have not returned till date, an affidavit of Dusty has been filed. Let us await for some time, maybe
It's okay.
Wakalatnama might be filed.
We can await some time.
She is an accessory party, substitution. Okay, you have substituted
Yes,
respondent number 5.
the main application, no, the main application is for substitution of the appellant. The appellant passed away.
Oh.
Now this is an application for substitution of the appellant by his wife.
Appellant's wife.
Yes. We can await, otherwise.
It is reflected by office note dated 25/7/2025 that AD card for service of notice upon respondent number 5 have not returned till date, although an affidavit of Dusty service upon respondent number 5 has been filed. Since the service is effected upon only recently by way of Dusty, and no one has filed wakalatnama till date, it is in the considered opinion of the court that service upon respondent number 5, it is in the opinion of the court that some time may be awaited for representation on behalf of respondent number 5. Okay. List this matter after 2 weeks
After 2 weeks.
on a date to be fixed by the registry.
Hearing list, item 2.
In this matter, Your Lordship, on the last occasion, Your Lordship had directed that the case diary be produced. But the APP is still to produce the case diary.
Not there.
Not
Not
and
yet,
Your Lordship, in the meantime, the state respondents have filed an additional affidavit
Ah.
giving the status report. My humble submission, Your Lordship, is that in that case, the records may be produced by the SIT. They must be having all the records. The
They
case,
have produced the status report.
yes, the case diary, of the first case IO, and the case diary of the SIT also may be produced because they have all the records.
It has not been called for from the SIT.
Not yet. If Your Lordship will see the last order, just direction was given to submit the status report.
Produced a case diary. It was when? Oh, it was mine order,
Yes.
my order.
It was your order, my lord.
I had said to produce the case diaries.
So,
By the
Linda
addition,
was, Mary was there.
Mary. So you may kindly direct them to produce the case diary as well as the SIT records. I mean, the SIT can produce it. I'm sure they are in possession of all the required documents.
Otherwise, you have filed your affidavit bringing into record the report of the SIT, right?
Yes, my lord. In compliance of the order dated
This is the status report.
9/6/2025, my lord.
But case diary is not there.
Yes, my lord.
They can produce the records, Your Worship, then we can make an attempt.
You are saying there will be 2 records or what?
The initial case diary of the initial case IO will be there. Then after that, due to the protest petition filed by us, the SIT was formed. So SIT will be having its own records.
The case diary of the IO would be enough, my lord. It will be the same.
But it was handed over to the SIT after
Yes.
it was
Yes, my
constituted.
lord.
Yes. So SIT will be having all the records.
As per your lordship's last order, you had asked us to produce the case diary.
Yes. Case diary, why? It is not there today? I mean,
It's not there today, my lord, because the APP were to produce and ask for the case diary, my lord.
okay.
If your Lordship will see the additional affidavit which has been filed, the latest one, annexure 1,
Yes.
it is by the team leader, SIT. If your Lordship will see the last affidavit,
Filed on,
it's filed on, Your-
additional affidavit by respondent, state respondent,
yes, Your Worship, in pursuance of the order dated,
26/2.
yeah, 9th of June.
Yes, 9th of June.
The last affidavit filed by them, in pursuance of the directions of this Honorable Court on 9th of June. I think we filed.
27 January, I have 9th of June.
No, in pursuance of the order passed by your Lordship on 9th of June,
Yes.
an affidavit was filed recently. It was, I think it was
Because I
filed
have one additional affidavit.
19th
oh,
of
yes,
June.
Yes, 9 June, yes, I've got it.
19th of June. I think.
Yes.
So, if your Lordship will see the annexure 1, it is filed by the team leader of the SIT. So the SIT team leader will have all the records. They can produce that.
Okay, you just write. In view of the last order, dated 9/6/2025, by which the learned additional advocate general for the state of Mizoram was directed to file an affidavit bringing into record the latest instruction on the status of the investigation carried on by the SIT. I think I've started the sentence with a wrong. How did I start? In view of the choro, you say that in the last order. A direction was, okay. In view of the same, the affidavit has been filed. On
26/2025.
26/2025, and the same is placed on record. However, a further direction was given on 17/6/2025 to the state respondents to produce the case diaries of the instant case. However, when the matter is called today, the learned additional advocate general submitted before this court that the case diary could not be produced for valid reasons, and as such seeks some more time to produce the case diaries. It is prayed by Mr. Malhotra, appearing for the petitioner, that case diaries in respect of the investigation which was conducted by the state police initially, as well as the case diary in respect of the investigation carried on by the SIT after the investigation was handed over to them, is required for adjudication of the present matter. The prayer is allowed. Both the case diaries is called for in the case. Both the case diaries from the IO, the erstwhile IO who was investigating the case, as well as the case diary from the special investigating team to which the investigation was handed over are called for.
I'm fine.
Okay? List the matter after 2 weeks.
Obliged, my lord.
After?
2 weeks.
On a date to be fixed by the registrar.
Item
This is otherwise a very old matter should have been disposed of, right?
Yes,
Yes,
Your
my
Honor.
lord.
On the next date, an endeavor should be made for disposal of the matter.
I'm open.
Item 3.
Item? 3. Oh, yes. Item 3, Mr. J.C. Lalsunanga. Anyone ready for part 2 matters? There are amicus curiae matters also.
I think no one's there. I'll inform the I'll inform the parties, Your Worship.
Otherwise,
Yeah.
things are over. Court is over. At least the criminal appeal could have been done by the amicus curiae.
I'll inform.
Joseph, I think he appears. Last time also he
yes.
appeared and did matters.
I'll inform the party. Maybe they are legs in. I'll inform the parties, Your Worship.
You do one thing, inform them. If they come, let me know. I'm here. We can come. I'll again come. We will assemble again if someone comes.
If someone comes up.
Try to inform Joseph. I think he can do it. You also have a matter criminal appeal, Mr. Malhotra?
Yes, but ours is tomorrow. Item 1 is fixed for tomorrow.
No, item number 6.
6, Your Worship, again.
Lordship,
Because
on behalf of my senior, if the item number 7 of hearing list be passed
Taken
over
up
for
today?
today.
Huh?
No, pass over for today.
For the day.
Today, yes, my lord.
Tomorrow you'll do it.
I'm not sure.
Achha, your senior is Lalmeranga.
Bilaram Enga. We are
Okay.
for the appellant.
Okay, try to do it tomorrow. Tell
Yes, my
him.
lord.
Okay.
I'll inform him.
Otherwise, 2022 matter, let us dispose it off. No purpose keeping it pending.
Yes, your lordship.
Do it tomorrow.
All right.
Okay, call it tomorrow. And Mr. Malhotra,
Your
item
Worship,
6.
this item 6, Your Worship, my learned, my junior is taking up the matter. This can come up on Monday.
Monday next.
Yes, coming Monday. I
Do
think,
it this week? Not possible.
Your Worship, he's spoken to the PP. Anyway, if it can come up on Monday, Your Worship.
Acha, theek hai. Now, this list is only till Friday.
Yes.
Try to do it by Friday. Thursday is a hearing day. What? You can do it?
Yeah, I'll see, Your Worship.
Okay, try.
Yeah, we'll
So
try.
whoever is ready, please inform.
Yes.
And I'll be here. Let me know. I'll come. Okay. There's no way out.
2 weeks, no 3 weeks. 2 weeks. 2 weeks.